Good afternoon. My name's Duncan Matthews. I'm the director of the Queen Mary Intellectual Property Research Institute, and I'll be moderating today's event. Thank you to our team of speakers who are members of the Queen Mary Centre for Commercial Law Studies project team on the establishment of a specialised IP court in Ukraine. So our team members today, Professor Ioannis Kokkoris, Dr. Noam Shemtov, Mariia Tymofiienko, and Dr. Olga Gurgula will be talking about their role in this amazing project, which the Centre for Commercial Law Studies has been conducting over the last few years. Without further ado, I'll hand over to my colleague, Dr. Noam Shemtov, to carry on the introductions. But just a final remark, in my role of moderating the session, please type your questions or comments using the chat function on Zoom, and I will address those to my colleagues at the end of the session today. So we'll probably have about 45 minutes or 1 hour of presentations and talks from my colleagues, which will leave plenty of time for discussion and chat at the end, which I'll then moderate. So with that introduction done, I will now stop sharing my screen and hand over to Noam Shemtov.
Thank you, Professor Matthews. Thank you, Duncan. And first, I would like to start. It's not the best starts, but I would like to start with an apology for my off-camera mode today. I woke up this morning only to realize that Sky is doing some maintenance work in my area. Therefore, I will be tethering. But I assure you that I'm the only one who would be in that mode. The rest of my colleagues would be here live and on camera. So, as you probably know, what we intend to share with you today is some insights that we gained during this project, where we advised the Ukrainian government both on the setup and operation, as in the procedural framework of a specialized IP courts. We had some brilliant team members. The key ones are here today, and I will introduce them briefly with their respective contributions, and then move on to our brief, and I assure you that they will be brief presentations. Professor Ioannis Kokkoris, who led the project together with me, jointly with me as the co-director of the project, and you're going to hear some fascinating insights from him. His contribution was invaluable in relation to all aspects of leadership of the projects of such nature involve. We had a fantastic time together in Ukraine, meeting all the relevant stakeholders, getting to know together this fascinating country that is, in our view, packed with potential, and the people that live, that work there. Yeah, it's been fantastic, and I'm sure he's going to share with you some of the interesting insights, as I said, from our time in the project. And indeed, Ioannis and myself were the two, you see the group before you, the two non-Ukrainian from the four which sit here before you. So the whole experience of Ukraine, the Ukrainian judicial system, and so on was completely new for us. Mariia Tymofiienko, well, I mean, what can I say? As a project manager, Mariia has been vital, no less, for the project, for its very inception, through its running, all the way to its completion. She overcame practical, administrative, logical problems throughout the project and made sure that things work according to plan. And when plans, as often is the case, plans had to change, she was always there to suggest and support alternative plans. Yeah, again, she's been nothing less than fantastic. Last but not least, and I guess a lot of you are here in order to listen to that part in particular, and that's the research related part. Dr. Olga Gurgula, who is now at Brunel, but used to be with us in the past. Olga was responsible for one of the two key pillars of the project, the research output, although contributed a lot to the training aspect as well. This involved managing an international research team that carried out an incredible amount of research, and at times was actually unstaffed or understaffed. I recall a number of phone calls that we had when she was not sure whether certain stages of the planned research can be completed on time, and in the end, she always came through, sometimes doing indeed extra work herself. As you can see, and indeed the project report is available online. It all resulted in a comprehensive, detailed output that would be of great use to the Ukrainian government, and I'm going to speak about that a little bit later, when they take the very final step and bring it to its final end, and that's meaning implement our findings. And as I said, I will say a few words on that in the end. And now I will hand you over to Mariia, I believe, that would give you a description of the project, the four corners of the project. What was it about? How did it come about? And how did we go about carrying it out? Mariia, please.
Mariia, you need to unmute your mic.
Just a minute. I will be opening my slideshow in a second. And thank you very much, Noam, for your introduction, and also for Duncan for his organization of today's event. I must say to the audience that Professor Matthews, Duncan has been also very essential to the success of the project, as he has contributed significantly to the initial stages of proposal development and helped us to win the award for the project, which we were working on for the last 2.5 years, and which I had the pleasure to manage as a project director. I'm still struggling with my slides, so just give me a second, please. I think I should be all right now. Okay. Thank you. It should be working now. So in today's presentation, I will cover following topics. I will speak about the rationale for the UK government support to support our work on the Big Port project in Ukraine. I will say a few words about my experience of working and managing the project and working with our amazing team on the project. I will present the deliverables, the work that has been covered in our project, and speak a bit about challenges and lessons learned as a result of our work and our experiences that were fascinating in the course of our project. Perhaps to begin with, I need to bring to your attention the rationale behind the UK government support for the project and for the IP court in Ukraine. This idea to generally the UK support was originated from Boris Johnson's visit to Ukraine back in 2016, when in his role of, he was at the time UK Foreign Secretary, and he had an idea that UK could assist Ukraine with its reform efforts by sharing the skills and expertise of its renowned justice sector. And back in 2016, Ukrainian government has introduced judicial reform bill, which provided a radical reform of the courts. As part of the concept, the idea was to create two specialized courts, mainly the Anti-Corruption Court and High Intellectual Property Court. The reasoning behind this approach was that previously IP cases were heard by 3 different jurisdictions: administrative, civil, and commercial courts. And this led to a number of problems associated with the enforcement of the IP rights in Ukraine, such as quality of judgments was incoherent, there was lack of predictability, and the proceedings were very long. So as a result, the solution was chosen to set up a specialized intellectual property court that would deal with improving the predictability and efficiency of the court proceedings, and also that would allow the judges in Ukraine to enhance their knowledge of specialized matter of IP. And back then, in 2016, I have been working in my PhD research and interviewing representatives from the presidential administration. And in the course of this interview, the idea came up that CCLS, QMIPRI, could assist Ukraine with the process of the setting up of the intellectual property court. And we were very grateful for the support that we received from the British government. The funding that we received came from the UK Good Governance Fund, and it was a significant award of £860,000, which is a big project for CCLS to date. And the other element why Britain supported this work is, of course, because Ukraine remains and is a strategic partner for the UK, especially in the trade relationship. Ukraine and UK has recently signed a trade agreement based on the EU-Ukraine Association Agreement, and there is an expectation that there will be continuous growth of trade and cooperation between the 2 countries. Ukraine, as some of you know, has a strong innovation base and has a prominent ICT sector, which is the 3rd largest export sector of the Ukraine's economy. And the cooperation between the 2 countries, especially in the R&D and high-tech sectors, will be beneficial for both countries, especially for Britain in post-Brexit world, where Britain is looking for new partners, and for Ukraine, as of course, Britain would bring advanced technologies and much needed capital. So the effective protection of IP rights becomes really critical to future trade relationship between Ukraine, UK, and also other international partners. And Ukraine has done already a lot of work to improve its IP protection system. A number of substantive IP laws have been adopted recently to harmonize Ukrainian legislation within the EU legal framework. And the creation of the IP court will be this final element of the effective functioning of the IP system in Ukraine, which will benefit the economy, will benefit, create better business environment, and generally will benefit Ukrainian innovative, creative sectors of the economy. I would like to say a few words on top of what Noam has said about our project team. And of course, I would like to say a few words about our project directors, without whose leadership this project would not have succeeded. And Noam, Professor Noam Shemtov, has himself been many times with us on the project to Ukraine and delivered amazing lectures on very interesting subjects of IP to Ukrainian audience, and those meetings and lectures were always gathering a full house. And Dr. Ioannis Kokkoris have contributed to our project with his high level of leadership and crisis management, and helped us to navigate through ups and downs of the project. And I guess the unique feature of the project is that our research team that consisted of some younger researchers, PhD and LM students, also who were able during the project to work with some very distinguished leading international IP experts. international and Ukrainian experts. And of course, our research team, as Noam mentioned, was coordinated by Dr. Olga Gurgula, who will say later present herself, but she's a Ukrainian IP lawyer with many years of experience. I will also mention the researchers that have worked very hard and delivered amazing work under very tough deadlines. To name some, I must say, must name Maciej Padamczyk, Alina Trapova, Marie White, Stanislav Labon, Herman Hartmann, who have been brilliantly managed by Olga. And also, I would like to mention that our research team has benefited from contribution from our Ukrainian experts, the retired judge Viktor Moskalenko, who was in the past deputy head of the Ukraine Commercial Court, and Anna Stefan, who is also with us today on the line, who is a head of the Copyright and Related Rights Department at the Ukrainian IP Institute. And last but not least, I would like to mention Olena Bardamatska, who was our coordinator on the ground in Ukraine, who made sure that that everyone in the IP community knew about our team and participated in all the meetings that we have organized in Ukraine. I would also like to mention that it was an incredible honor to work with the International Advisory Board that has been especially created for the project and included well-known stars of the IP world. I have listed the board names on the slide, so I'm sure many of you will be familiar with the names of these judges, academics, and practitioners from UK, France, Germany, Netherlands, US, and of course, most importantly, Ukraine. The board was chaired by Lord Neuberger, former president of the UK Supreme Court, who spent so much of his time and effort directing and working with us, directing the International Advisory Board and working with us, that he also visited Ukraine on many occasions and met key stakeholders in Ukraine, that I think we could call him the godfather of the IP court once the IP court is created. Furthermore, I'd like to mention that the critical aspect of the project was the communication between the key stakeholders from Ukraine, including members of the judiciary, judges from the Supreme Court, members of parliament, government officials, and also we worked very closely with diplomatic circle, specifically with the UK embassy. Ambassador Melinda Simmers has provided an incredible support to us and participated in a number of our meetings that we organized in Ukraine. And also the team of the embassy, that is very professional, has supported us throughout the project, as well as FCDO team in London. I would also like to thank the support from the professional and business community, professional lawyers and business community of Ukraine, who have assisted us and participated in the project. And they play a major role in pushing reforms in Ukraine, so their support was really important. In terms of project deliverables, I would like to highlight the most important elements of our work. As Noam already mentioned, the key deliverable was to prepare research outputs such as gap analysis of Ukrainian legislation, comparative research study of international best practices, UK, France, Germany, Netherlands, and the US. On the basis of which we then developed project recommendations and roadmap. The result of this work turned into 150 pages comprehensive report, and my colleague Olga Gurgula will be presenting the findings of the report later. As I also mentioned already, the key to success in this changing political environment in Ukraine remained to work with all the parties, all the stakeholders on the ground. And over 2.5 years, we organized numerous visits to Ukraine. We made sure that no matter who is in government, who is leading the country, the IP court should and would and will and is remaining on the top of their agenda. We also organized a series of face-to-face and written interviews with the expert community to inform us about views on the gaps in the legislation and ways to overcome them. The project recommendations were discussed at regional roundtables, and we have a wonderful experience of visiting these beautiful cities of Lviv, Kharkiv and Kiev, and I'm sure my colleagues Noam and Ioannis will tell more about their experience. I would also like to say that the role of the International Advisory Board in reviewing our recommendations and providing their valuable input was very important. It gave us confidence that our recommendations are according to the international best practices and standards, and that they can actually be applied in Ukraine. The other important element of our work was delivering a training program for Ukrainian IP judges. But of course, we had a number of challenges that we had to overcome before we were able to complete our work. And one of the major problems was that the High Qualification Commission of Judges that was responsible for the selection of judges to the new IP court was dismissed halfway through the project. So the competition has not been completed. And we were left in a limbo with a process that has not been finished, and the process of selecting the new High Qualification Commission is still ongoing. We hope it will be finished by the end of the year, and we have heard from the presidential office and other responsible officials that there is a focus on completing this process as a matter of priority. And of course, the other problem that we faced was that everyone in the world has faced is COVID-19 pandemic, which had a big impact and made it difficult for us to travel to Ukraine and to deliver face-to-face training program. And we had, as a result, to redesign our work to deliver online training program in order to recreate this face-to-face experience as much as possible. But actually, it turned out to be a positive situation because training program actually has been probably delivered in a better form than it was previously envisaged. The online format allowed us to increase the number of participants from previously envisaged 30 to more than 100 participants, and we had current judges participating in the program, also candidates who are applying to become judges of the new IP court, and members of the appeal chamber at the IP office. The program took place over 3 weeks and covered the subjects of main IP rights protection and court procedures in different countries, which also reflected our work on comparative study, our research work. And the program has been delivered by amazing trainers. And again, I've listed the names of the trainers so that you could see who has been delivering the training. All of them are very famous names in the IP world. And we gathered feedback in the process of the lectures from both participants and trainers, and the feedback was very positive. And the average score by the participants on every lecture was 4.8 points out of 5 possible points. And we are most grateful for the feedback we received from both trainers and participants. And the feature of this online training program was that it was interactive. The content was streamed live. It was simultaneously translated. The participants were able to ask questions, live questions, and get live answers. Materials and presentations were available for downloading ahead of the lectures. The recordings of the lectures were also available post-lecture. And I must say that this was an amazing undertaking to deliver it. And given that we only had 2 months to design this training platform and to prepare the delivery for online training program, I think it was an amazing result. And I would like to thank our technical partners on the ground in Ukraine, iCommunications company that helped us on technical side to deliver this work. And I would also like to mention that the participants had to take tests, and successful participants of the training program were then received certificates that were signed by Lord Newberger and Ambassador Simmons and Ian Walden, CCLS director. And we very much hope that the practical skills and knowledge gained in the course of the training program will benefit the judges and future judges and will improve the quality of IP education in Ukraine. Last, I'd like to look at the lessons learned and the way forward. And we hope that with the renewed focus of the judicial reform by the presidential team, that there will be the optimistic scenario of having the IP court operational by the end of the year will be possible. And of course, it depends on how all the partners, interested parties work together to achieve that result. And we remain in touch with our partners on the ground and remain available to provide further assistance in this work. We hope that the High Qualification Commission setup will be finished by autumn this year. And it is also very important that the legislation will be amended to fill those gaps that we have identified in our research, and that our recommendations in the roadmap developed in the course of the project will be implemented by the new legislation. So I hope that it was an interesting presentation about our work, and I would be happy to answer any of your questions now, or if you want, you can drop me a line on my email mentioned on my slide. Thank you very much for your attention. And I will pass the floor if Duncan is not at the moment.
I think Mariia, I think now it's a good time to maybe pass it to Ioannis, then Olga, and then I will say a few words at the end about the way forward. So let's do it like this. Ioannis, over to you.
Yeah, thanks, Noam. Thanks to Mariia, to Olga. It's very nice to actually see the project team again, and thanks to Duncan for actually inviting us to present at this seminar, so we can actually get the chance to see everyone again and remember exactly what we were doing during the project. And as Mariia mentioned, Duncan was the one who pioneered with Mariia and Olga from CCLS point of view the whole idea about this project, and then Noam and I came in a bit later to actually run once it was awarded. So Duncan, thank you for actually being able to make sure that we are here today. Between Noam and myself, Noam is clearly the IP brains, so I'm not an IP expert. Mariia and Olga are also IP experts. So my role in the project team was mainly to engage with stakeholders, of course, together with the whole of the project team. and that had different types of challenges, because we were entrusted with a significant sum of money by the British government to be able to make a change to the IP court system in Ukraine. And this is not just a matter of changing the law or changing potentially the way that judges may be appointed, but it's more about giving Ukraine the possibility to grow the potential of its economy based on a solid IP regime. And this is way broader and more important than our project in itself, and it's way broader and more important than an IP law or a set of IP laws. So we had a significant responsibility to make sure that what we were doing in Ukraine, we were confident that this was, to the best of our ability, in the interests of the Ukrainian people and Ukraine as a whole. And in these types of projects, when you have your client, when you have your beneficiary, and when you have third parties which have a legitimate interest to be involved in the process, there are different types of interests which are created and at times clash. Especially if during the lifetime of a project, you also have a change in certain significant stakeholders in the host country's government, which was the case for our project, then this creates additional challenges in the sense that you need to persuade, if you wish, of the value of what you're doing to a new group of stakeholders. And you need to do that not just to ensure that the work that has been done until that point is not going to be scrapped, but also to ensure that the new stakeholders who have come in, and this happens on many projects in many countries, the new stakeholders who have come in actually do share the same priorities and can see the value in the work that the project team is doing, and in the work that we felt that we would be able to keep our heads high in saying that we did our best to actually promote the IP regime in Ukraine. And so part of my role, of course, in conjunction with the other members of the project team, was to navigate through the different types of interests. And at times they were positive for us, so they were agreeing with our approach, but also at times there were disagreements. And there may have been disagreements on different issues by different stakeholders. So it becomes an interesting persuasion. I would call it game. It's not a game, but it's actually a persuasion exercise, because you as the project team, you are confident of what you are doing, and you know what you feel is right from an academic and an expert independent point of view of your recommendations and your suggestions. So when you are in meetings, either open meetings or closed meetings, and you need to discuss with interests which may be opposing your views, you need to stand your ground. And you need to do that whether this is your client or beneficiary or a very influential third-party stakeholder. And the whole project team was standing its ground on difficult discussions on occasions with very interesting individuals, when we would be suggested that we would potentially see it in a different way. But it's always important in these types of activities, in these types of work, to keep in mind that you are there because you know well an area of law, but at the same time you are there because you don't want just to transpose your knowledge, which is not related potentially to the country. Because as Noam said, neither myself nor Noam have any experience of Ukraine as a country, of the Ukrainian economy. I'm not even an IP expert. So we do not engage in such type of projects to go in and say, this is what we know works well in Europe or in country X, and this is exactly what will work well in another country. It's about adapting what we feel works well abroad, adapting it for the realities of the country and the economy that we're actually working in. And sometimes things that work well abroad may not be ideal for a particular country for different types of reasons. So our assessment and our approach in these types of work, because CCLS and QMIPRI are engaged frequently in these types of work, is not about we will come and tell you how to do things. It's we will come to hear how you want to do things, and we can give you our view on how we think this can be best done. And at times, when we adopt this approach, this will be positively seen. But of course, as in many projects, there will be challenges when you do face individuals who may have certain ideas that do not want to easily listen to an opposing view. So it's been a really fascinating experience. We've had meetings at senior levels of the government, at senior levels of the UK government as well, both in Ukraine and also here in London. So it's been a fascinating exposure to different types of perceptions and different types of perspectives. And I think the whole project team, it's not the four of us that we speak on this session today, but also it's Olena and Anna that Mariia mentioned, who I also saw them on the list, but also all the other colleagues that Olga worked with, and all our friends, because I think after this project, I can say I have friends now in Ukraine. So I can go back for another project or just on vacation. I haven't seen the place I'd like to see in Ukraine yet. I would like to go back and I have friends that I'm very happy to share very good memories with. And I tried amazing Ukrainian dishes and amazing Ukrainian wine, and I look forward to the next opportunity to go back. Thank you. Noam, I don't know if you'd like me to say anything else at this point, but I'm happy to share any more memories.
No, I think that was fantastic, Ioannis. Thanks. And actually, in a very short presentation, you I think managed to capture both the essence of our experience, but also of what we actually did there by saying that it was providing advice via dialogue rather than one directional. When we tweaked, adjusted what we were providing on the basis of this dialogue in order for it to fit the unique factual matrix in Ukraine. So I think now it's time to move to where we have most of the meat on the bone today, and that's the research element. So Olga has the unenviable task of trying to cram into a short period of time both the framework of the actual research exercise, but also the essence of our findings and the reason for them, and that is based on, I believe, correct me if I'm wrong, Olga, a report which is a couple of hundreds of pages long, but you're going to do it much shorter. So Olga, over to you.
Thank you, Noam. Hello, everyone. My name is Olga Gurgula. I'm a lecturer in IP law at Brunel University, London now. I qualified as a Ukrainian attorney in 2004 and worked in private practice for over 10 years, including representing clients in courts in Ukraine. I also did my PhD at QMIPRI, and two of my supervisors are here, Dr. Noam Shemtov and Professor Duncan Matthews. Hello, happy to see and hear both of you. My role on this project was to act as a project research coordinator. And I had the honor of leading a fantastic team of researchers. Some of them are here, and I will mention them in the end of the presentation. And that work was done under a fantastic guidance of Dr. Noam Shemtov, and together we prepared the final report and recommendations. Next slide. Right. I think to understand the importance of creation the IP court in Ukraine, it's probably good to explain first the situation with the adjudication of IP disputes before the creation of the IP court. In the past, in Ukraine, IP disputes were traditionally considered by three different types of courts: commercial, civil, and administrative courts. And these, of course, provided different options for resolving IP disputes. But this system had a significant disadvantage because it routinely generated confusion as to the jurisdiction of those courts in such IP disputes, and also it frequently resulted in very lengthy judicial processes and different courts' practices. Because of the different level of expertise in courts and different procedures, this very often led to different unpredictable and inconsistent outcomes in similar IP disputes. And therefore, it has long been argued by the Ukrainian legal community that it is important to create IP specialization in Ukraine in order to overcome these problems. And over the last maybe decade or so, the discussion on how to improve the quality of IP adjudication can be split into two main groups or choices. First, there were arguments that we need to establish a separate IP court, or that we need to create specialized IP chambers within the first and second appellate courts. And eventually, the first option obviously prevailed. So in 2016, the Parliament of Ukraine adopted the law on the judicial system and the status of judges. And this law has brought, in general, a lot of changes and significant transformation of the judicial system in Ukraine, but it also created a new specialized IP court. It was supposed to be established within the 12 months of the date when the law came into force, which is September 2017. But until today, the court is not operational yet. Before I delve into our research element, which will be very quickly, I also want, I think that it is important to kind of say a few words about the design of the court. The new IP court will operate as the court of the first and appellate instances, and it will be located in Kiev, in the capital of Ukraine. The first instance will comprise 21 judges, and the appellate chamber will have 9 judges. All IP disputes in the first instance will be considered by a panel of 3 judges. The court will have exclusive jurisdiction in relation to a wide scope of IP disputes, including disputes related to patents, trademarks, registered designs, utility models, and authors' rights. It will also have jurisdiction over disputes concerning IP-related agreements and also unfair competition, and will have the power to recognize trademarks as well known. Now, while the creation of IP court is generally considered in Ukraine as highly desirable, there have been concerns that its setup may require some improvements. And therefore, the aim of this project was to provide recommendations to the Ukrainian government on possible ways to improve the legal framework that relates to the creation and functioning of this new IP court. And because of this, our work was split into several stages. So we started with analysis of the Ukrainian law that related to the establishment of the court, and also the procedural law that the court will be applying. So in our first Ukrainian law report, we identified certain issues that may impinge on the effective functioning of the court. And then we moved to the second stage, in which these problem issues that we identified in our Ukrainian law report, we further analyzed as part of our comparative study of best practices in a number of mature jurisdictions, and these are US, UK, Germany, France, and the Netherlands. And of course, one of the most important stages of our project was the last stage. Based on these findings of the comparative study, we developed recommendations on possible ways of how to improve the legislation and in order to improve the functioning of this new court, and we also provided the roadmap on how to implement our recommendations. Now, let's briefly look into the substance of our recommendations. The recommendations consist of two elements. The first part focuses on the issues that relate to the establishment of the IP court, and the second part elaborates on the recommendations related to the procedural aspects and then the procedure that the court will apply. Of course, it won't be possible to cover all the recommendations. It's a huge document, and Noam mentioned it's more than 200 pages. But I will outline perhaps those that are, in my view, the most important. So recommendations on the establishment and effective functioning of the court included several issues that related to the structure of the IP court, the selection criteria for IP judges, location of the court, and number of judges. So within this section of recommendations, I think that the most important issue related to the selection criteria of IP judges. And there were a number of problems there, but I think that the most problematic issue related to the specific selection criteria for IP judges. So while the requirements in the law for IP professionals, such as patent attorneys and attorneys at law, are very strict and require at least 5 years of IP experience and practice and sufficient evidence of such experience. Interestingly enough, the current law sets a very low threshold for IP judges candidates. Okay, so the threshold for candidates who are judges is set at a very minimum level, and it's only 3 years of being a judge with no requirement of actually adjudicating IP cases, that's significant to as we could see that, because the current selection criteria may essentially result in some of the IP judges lacking sufficient knowledge in IP. And there is also no requirement as to the relevant technical background for IP judges, and this knowledge may be particularly important for adjudicating such complex IP disputes that are, for example, related to pharmaceutical patents or software patents. And therefore, we recommended establishing a general requirement of possessing an adequate knowledge in the field of IP for all candidates. And we believe that this will ensure that the IP court comprises experienced IP judges who will deliver high quality IP adjudication. We also recommended introducing the Institute of Scientific Advisors, following the example in the UK, which are technical or scientific experts. They are not party experts, who may be appointed to advise the court on specific scientific or technical issues within the scope of their expertise. And also we recommended considering the possibility of reserving a certain number of posts for IP judges with a relevant technical or scientific background, also following the practice in Germany. In Germany, they have technical judges that adjudicate patent disputes, but also in the UK, many IP judges have technical and scientific background. Also, the location of the court is very important, as it may impact on the access to justice. As I mentioned, the court will be located in Kiev, which may make difficult for litigants located in other remote regions in Ukraine to access to this court. And we therefore recommended several options that may facilitate such access. First, we recommended establishing the obligation of the IP court to conduct court hearings via video conferencing if party has demonstrated sufficient grounds. Further, if, for example, the case has a clear regional connection and if the trial via video conferencing is not practical, for example, because there is a lot of big number of participants or amount of evidence is significant, we recommended that the hearings may be conducted in that region in question. And for that purpose, the IP court could use a building of a local civil or commercial courts, or in case of a significant number of IP litigation in the future, then permanent regional divisions of IP court may be established in major Ukrainian cities. And that would improve access to justice and to this court. Finally, currently, cases in the first instance must be considered by a panel of 3 judges. And considering the high number of IP disputes and small number of panels in the first instance to consider these cases, this casts doubts on the ability of the IP court to perform its judicial functions in an effective and timely manner, and therefore we recommended increasing the number of judges. We also recommended that certain issues may be considered by a single judge, for example, simple cases or granting a preliminary injunctions. This may not require a 3-judge panel to decide such issues, and therefore this could speed up the process and reduce the workload for the court. The second part of our recommendations concerned procedural issues. The new IP court will apply the Commercial Procedural Code, and we analyzed the provisions of this procedural code to see how the process of adjudication of IP disputes could be could be enhanced. And we identified numerous issues that might impinge on the effectiveness of this court. And this includes the composition of the court that I already mentioned earlier. We also looked into preliminary injunctions, cross-undertaking security for cost, and provided some recommendations based on best practices in leading IP jurisdiction on how to make these mechanisms more effective. But perhaps the most significant issue that we identified related to the exclusive jurisdiction of this court. As I mentioned, the jurisdiction of IP court covers a wide scope of IP and unfair competition disputes. However, some uncertainty remains as to the scope of the jurisdiction of this court in relation to certain IP-related disputes, and this may lead to the overlaps with jurisdictions of the administrative courts and other state authorities. And a good example of such an overlap is tax and customs IP-related disputes. At the moment, such disputes fall under the jurisdiction of administrative courts, even if these disputes involve IP element. But often an in-depth understanding of IP law is essential in order, for example, to define whether whether a company has relevant IP rights to an IP object that is the subject of tax and customs dispute. So in essence, the subject matter in this type of cases is IP rather than tax or customs related issue. And therefore, we recommended that such tax and customs disputes that involve IP element should be covered by the exclusive jurisdiction of the IP court. And the jurisdiction of this court would only include such disputes if IP specialization is necessary to resolve the dispute. And the last that I want to mention in my presentation is that I would like to thank once again our amazing research team. They worked very, very hard throughout this 2.5 years of this project. Noam mentioned that we had a very strict deadlines, and this is thanks to them that worked days and nights, and I'm not exaggerating, on this project. And in particular, I would like to thank our national expert, Ioannis, who has been absolutely amazing. She's here with us today. And also our research assistant, Maciej Padamchuk, Alina Trapova, and Marie White, and also our international rapporteurs. Without them, the successful completion of this project would not be possible, of course. And thank you very much, Mariia, for your great management of the project, and to our directors, Noam, Shemtov, and Ioannis Kokkoris for their management and direction and guidance of this project. Thank you very much.
Thank you. Thank you, Olga, and thank you for managing to cover such an extensive topic in a fairly short period of time. I would be very short. We would like to leave as much time as possible for questions and answers. So the project, our findings, our recommendations were viewed positively, both in Ukraine and generally globally by experts that we conversed with. Of course, it is most important for it to be viewed favorably in Ukraine. It is in Ukraine when it is hopefully to be implemented. Now, in Ukraine, whether in academic circles, judiciary, all the way to the Ukrainian Supreme Court, from the president of the Supreme Court to the expert IP judges in the Supreme Court, there was and still is, I could say, unequivocal support. But of course, most importantly, it must have support in the political circles. Now, the establishment of the the IP court, specialized IP court in Ukraine, is viewed in Ukraine and by Ukrainian legislatures in line with Ukraine's international obligations under its association, for example, association agreement between the Ukraine and the European Union. In conversations that we had with government ministers, Ukrainian parliamentarians, such as the heads of relevant Rada committees, Rada being the Ukrainian parliament, we received nothing but positive, by and large, positive feedback, both the importance of setting up the court and the appreciation and the rationale behind and the benefit of our recommendation was expressed to us in a variety of ways by relevant political actors. The process has been set in motion, and the selection process for the judges for the court already commenced quite a long time ago. However, as Mariia alluded to, after the change of government, the person who was heading the High Qualification Commission of Judges in Ukraine has left or was dismissed, I'm not sure exactly. And this meant that the commission could no longer continue with its role to complete the selection process. And of course, without the selection process, you have no judges. Without any judges, you have no court. To the best of our knowledge, this commission is still not operative. And this is now, as I said, for the good part of 1.5 years. Again, I believe Mariia made a comment in that respect. We do understand that very recently the relevant Ukrainian parliamentary committees recommended to the parliament on the amendments of the law to Ukraine on judiciary and statute of judges, and among other things, on the resumption, as part of this legislation, on the resumption of the activities of the High Qualification Commission of Judges. When that takes place, the process is envisaged to be completed within a few months at the most. What is, depending on the perspective, I guess, is either interesting or maybe worrying, or at least should be handled with care, that's my personal opinion, is that there appears to be quite some support for the IP court to become a pilot project for what, and again, I do not understand this in full, so it may be this which prevents me to appreciate the full meaning of the thing. But one of the ideas that are floating in Ukrainian parliament at present is to have this court implementation, or there is a pilot project for the implementation of electronic justice on the basis of what is named or called Unified Judicial Information and Telecommunication Systems. The idea is that the IP court would immediately be part of what is referred to as, and I quote, courts in a smartphone system. And the thinking behind this appears to be that it would be beneficial to have an electronic procedure from the moment the court is established, rather than going through the painful process of replanning and changing an existing structure that exists. Now, the thing is that we are not entirely clear what exactly is meant by electronic procedure. There can be only net positives to the whole thing, but we need to know more. This is why I mentioned that we are looking at it with a cautious interest. How feasible and how practical and how conductive all of this may be to the delivering of an effective, fair, and predictable framework for adjudicating IP disputes, which in essence, this is what our project or this project was about. Well, I guess time will tell. And with this, I will thank you all. I've finished my short presentation, and I will hand it back over to Duncan. As you heard, and I was intending to mention that in the very end, and to thank Duncan. Duncan has, except for chairing this project, has and had a clear part in the inception of this project. So again, thank you, Duncan, for that. Duncan, over to you.
Well, thank you, Noam, and thank you to the project team for those excellent presentations. Perhaps I could start with an observation about the origins of the project, since Noam kindly mentioned this, and Ioannis and Mariia also earlier. I was struck when I was working with Mariia and Olga on the proposal for this project, and I think we were working for nearly 1 year. It certainly felt like 1 year we were working on this back in 2017, that we were doing this project and putting this project proposal together because all of us cared passionately about Ukraine and the independence of the rule of law in Ukraine. So it was a project that all of us have believed in very emotionally from the beginning. And I think that's probably why the project has been so successful, because despite the challenges and the difficulties you've had completing the project, it's really a project which was sort of close to our hearts. I'll just make a few observations now about the excellent presentations that you made, and maybe we can start a discussion with the team and also others who are online. I know some of the project team are online. What struck me at the outset today was in Noam's opening remarks, he referred to the different pillars of the project. Of course, the training pillar, and the report that Olga was coordinating. But when Ioannis was speaking, what was fascinating also is that there was actually a third pillar to the project, which was about the coordination of interests. And thinking back to how we started the project, that's probably something we didn't really appreciate when we started the project. So it's interesting to reflect on that now. Also, Ioannis mentioned that, of course, this is just a small part of building a solid IP regime for the benefit of the Ukraine economy. And I think that's also a very important observation, that this is just one part in the whole picture of how Ukraine will establish a strong IP regime for the economic and social benefit. It's also interesting when Ioannis was speaking that he sort of explained how the project team had navigated between both the positive responses to the project team's activities and findings, and also perhaps managing these different viewpoints from different stakeholders. And Noam, I think, made an interesting comment about this as well, which I actually wrote down, which I thought was also great. Providing direction through dialogue. So this was obviously an incredibly important and time-consuming activity that the project team conducted. So that was really fascinating to hear about that. And Ioannis also talked about, the need for the project team to be principled and for the team to stand its ground where there were other viewpoints. The team really had this independence, which I think was fascinating to hear about and very commendable. And the fact that the team was also very open and honest, both about the unexpected outcomes and the biggest challenges, was, I think, great to hear about. I've got a couple of questions which are mainly about the report. So I'll perhaps start the discussion with Olga. But if any of the others in the team would like to chip in, please do. I'd like to make this an open discussion. And of course, we'll look out for questions in the chat box, which we very much encourage. So Olga, a number of things struck me about your excellent presentation. The first was that you referred to the role of a scientific background of judges. And of course, as we know, in the UK, many of these IP disputes can be very complex in terms of the technologies, whether that's in the life sciences or in smartphone technologies, for example. And I'm wondering, how important is it to have a scientific background? I mean, even although this is the case in the UK, we might find that a chemist who becomes a judge is hearing cases about smartphones, so the technology might be outside their expertise. If scientific knowledge is not always available, how do we sort of mitigate this situation? How do we ensure that it doesn't affect the conduct of the case and the decision? So I'll put that question to you first.
Thank you very much, Duncan. I think that this is probably one of the most important questions now, because the experience and knowledge that the judges have will determine the quality of the decisions that they make. And you correctly mentioned that a lot of disputes, especially in the patent area, are very technical and may require scientific background. So on the one hand, it's good that judges would have this scientific background, but as you also mentioned, not all the cases may require this knowledge. So what we suggested in our report is that all the judges must have the adequate experience, good experience in IP. So that's the base fundamental ground that should be implemented in the selection criteria. We also recommended to introduce the Institute of Scientific Advisors. So this would help those judges that have no scientific background and would educate them about the technology, would explain them how the technology works. So these are not the party experts. These would be advisors that work either in court or can be invited to consult on the case. And we could see that the similar approach is taken in the UK courts. UK judges may refer to scientific advisors when, and they essentially teach judges on specific technologies. So that may help Ukrainian judges to understand the technology and to better deliver the decision. But also, we thought that it could be useful to consider maybe allocating certain number of posts in the Ukrainian IP court for technically qualified judges, as it is the case in Germany. In Germany, they have certain number of technical judges. Essentially, they are not IP lawyers, they are technical judges, and they are involved in the panel of judges to normally that would be the patent cases. So technically challenging patent cases would involve the technical judges. So for example, trademark cases would not have this type of judges, but patent cases would have this technical judges. So we try to kind of cover all the possibilities for Ukrainian judges, that they have IP experience, they have advisors that could advise them, but also maybe allocating certain number of posts for technical judges that would be working in court. So that would probably cover your concern for high quality adjudication in Ukraine.
It's fascinating. So you've obviously thought of a number of strategies to deal with this problem. And as you correctly say, Olga, this is something which we find a hot topic in the UK also, when the court tries to construe and understand the claims in a patent specification. And, you know, I think Kirin Amgen was the first case in the UK where the English courts actually asked a professor from Oxford University to explain the biotechnology behind the invention. So it's interesting to hear that approach being adopted in Ukraine as well,
hopefully they will adopt, yes. At the moment, as I mentioned, there is a problem with the selection criteria, so we actually can end up with judges that have no IP experience at all. So hopefully they will change these provisions in the law.
Yeah. My next question, which struck me from your talk, which I also noticed in the excellent 200-page report, which I posted the link for in chat for everybody, is the location of the court. Clearly, this was sort of a controversial topic for discussion during the project. It struck me that, of course, we've had many of these discussions with the proposals for a unified patent court in Europe. And in Europe, a lot of emphasis has been placed on the need to ensure access and keep costs low for litigants. And I wondered whether you'd encountered this. I know you mentioned that perhaps regional divisions could be achieved in the future, but it would be interesting to hear a bit more. I know you didn't have much time about sort of what the concerns are in Ukraine about location of the court.
That's a very good question. Location was one of the important concerns that were considered and discussed by a lot of experts in Ukraine. And Ukraine is a large country, and locating a court in a capital may have a problem because a lot of litigants from remote areas in Ukraine would not be able to access the court, and therefore we looked into practices in leading IP jurisdictions, how they deal with this type of problems. And there are different approaches. For example, those jurisdictions that have IP courts, like UK, for example, or the US, they tend to provide access through, for example, video conferencing, as in the US. Or judges in the UK travel to a specific location to help litigants with their costings. And now we are establishing in the UK regional divisions of the IP court that would be also very helpful in improving access to justice. So based on this experience, we recommended in Ukraine that, first of all, currently in Ukraine there is no obligation for IP judges to conduct hearings via video conferencing. So we recommended that the law should be amended, and that the court should be obliged to conduct a hearing via video conferencing if there is if parties show that there is certain grounds for that. If it is not manageable to do by video conferencing, because, for example, there are a lot of parties in the case is very complex, there is a lot of evidence that needs to be considered. So another option is that the judges would travel to a certain region where the connection with the case is the most prominent, and would conduct hearings locally. But also we thought that because of the creation of the IP court, the number of cases of IP disputes will be increasing significantly, hopefully, and therefore this may require the establishment of the permanent IP courts or divisions of IP courts in major cities, like, for example, Odessa or Lviv, Kharkiv. So that would significantly increase access to IP court as well. So as of now, it would be difficult for many IP litigants to access IP courts, but hopefully when our recommendations are implemented, it would be easier.
That's a very important, I think, observation about the importance of access to justice and the extent that technology and video conferencing might assist with this. Just an observation also over the past year, both in the English courts and at the boards of appeal of the EPO, there was a lot of concern that having online hearings might be tricky because, for example, patent lawyers have said to me, oh, you can't see the body language of the other side, you can't see the body language of the judge, or these kind of intangibles. But as we've all been forced to use these online tools, actually most of the lawyers have said it wasn't like that. Actually, it worked perfectly well, and there was no tangible difference from doing things in person. So I hope that message will help in Ukraine also. I have other questions, but I'll look out for chat. Maybe just one more for the time being, Olga. I think this is clearly an important set of recommendations for the establishment of the court and for the and we've also talked in this project presentation about the training of IP judges. What about the lawyers? What about the lawyers who are representing the clients? Because I've seen this in other countries where specialist IP courts have been set up. But maybe the legal education of practitioners who will represent the clients will take some time. Is that something that you discussed at all with stakeholders or which arose in the project?
That's a great question. We haven't discussed in detail this because the project was focused on the IP court and the gaining the knowledge for IP judges. I think that we do have a large body of IP experts in Ukraine, especially patent attorneys and IP lawyers, that probably have a good knowledge of IP and would be able to represent their clients at a high level. The main problem in the enforcement system was with the court, because many judges didn't have this and still do not have the required IP knowledge to adjudicate cases. But I think that it's a very good comment. This should be considered comprehensively, and I think that because we have the training online, Mariia, correct me if I'm wrong, I think that we did have IP lawyers as well, and we also had representatives from the patent office as well. So we managed to cover a lot of experts, not only judges as well.
Oh, I see. That's very helpful. So the project didn't just restrict the training to judges. So it involved these other expert groups. And also when you were speaking, it occurred to me that undoubtedly once the court is operating and it is seen to be a success, that will in itself, I think, motivate lawyers to obtain the necessary training to represent the court. So I think
there is a lot of room for Queen Mary to do a lot of trainings in Ukraine.
Perhaps I just can chip in, Duncan and Olga, on this. I think one of the issues that Ukraine was trying to address is that there was an attempt to encourage practitioners to actually join the judiciary to become IP judges of the court. So one of the issues, and we have identified, is that it was difficult for practitioners to prove their qualification to qualify for the selection to become judges. So it is actually, in Ukraine, we have very solid knowledge between the practitioners and established kind of expert community of IP lawyers. And what we hope that there will be more incentives for these practitioners to join in and become judges. And I know that colleagues with us on the phone from the IP Institute, Anna Stefan, other academic institutions and patent attorney representatives are organizing trainings, and it's a very lively professional environment in Ukraine. There are many conferences, and a number of our professors from CCLS have been invited to speak at conferences, and I hope this exchange will continue. And I think just to refer to what Duncan, you said before about this goodwill, international support that there is for Ukraine, and that's what we really felt through the work of the project, that among academics, yourself and others, among the senior judges from different countries who were part of our advisory board, among the trainers, we have also trainers today, among our participants, Dr. Professor Makin, I can see, who delivered fantastic training in copyright. We felt that there is this fantastic support and desire for to share the expertise with Ukraine and to invite Ukraine to be a member of the Club of Advanced IP Adjudication Jurisdictions. So we hope we contributed to this process of dialogue and exchange of knowledge, and we hope this will continue when the project, once the project has finished, it will have its own life. These connections will work.
Yeah, I think that's a very important point, Mariia, that actually this was the start of a long process, and that the work doesn't finish here. This is probably the first stage in the development of a solid IP regime in Ukraine, but an important part of it. But great to see that there is this interface between not only the judiciary, but lawyers who perhaps are gaining more expertise in IP matters as well. So it's very interesting to hear how that all links together in this project and how it might develop in the future. So thank you for that. I'm aware of the time. Perhaps, I don't know whether Ioannis and Noam, you'd like to make any comments or final remarks before we end today's session.
Ioannis, you want to go ahead first?
Yeah, just one last comment. Actually, listening to Olga and Mariia describe the project and what we're doing in Ukraine, I forgot to add another complexity, which was not just trying to discuss the different interests of the beneficiaries and the different stakeholders, as I mentioned before, but also try to discuss with other funding organizations which may have been funding similar projects or projects which could be complementary to what we wanted to do. So, and there were a number of them who are supporting, or were supporting at the time at least, Ukrainian economy. So also discussing with them, trying to make sure that their priorities and their work adds to ours and vice versa rather than retracts. That was also another round of interesting meetings and exchanges that we had. So I'll stop here and I'll let Noam finish off our memories.
Perhaps before Noam contributes, I'll just read out a wonderful question from our colleague John Taylor. And perhaps before we close the session, maybe I'll allow all of you to give your thoughts on this. If similar projects were undertaken in the future, what single change should be made to facilitate them? So what one thing could be done differently in a project like this? But I'll let you think about that and hand over to Noam.
Thanks, Duncan. Again, I'll take very little time and I'll try to at least chip in with my thoughts on what John Taylor asked, and that goes back to what you mentioned actually before, what you described as the third pillar that was not necessarily in contemplation when the project was designed. And it is indeed this, the fact that it is a dialogue, and you need to, on the one hand, be principled as to the know-how that you put forward and you offer. On the other hand, you have to be fairly agile on your feet and tweak and adjust your offering, your service. Is essentially a service at the end of which there may be even a product in the shape of a report, and move with the moving circumstances. And quite often in these projects where which take 2 or 3 years, circumstances change. I will just finish with again thanking everyone, and again going back to the fact that myself and Ioannis realize that Ukraine is an amazing country. It's an amazing country with incredible potential, which is partially untapped, and it's untapped at least to a certain extent. It is our view that when it comes to the generation of knowledge and know-how, you want to have a solid system which is predictable, which is fair, and is effective to adjudicate disputes in the field of IP. We all talk about the information economy, knowledge economy, and it is indeed there where a strong and effective IP system plays a major role. And hopefully this report, this project, and this output can make a bit of a change in that respect and move Ukraine somewhat forward towards that objective. Thank you.
Thank you, Noam. And a final word, perhaps Mariia, and then Olga, and finally I'll ask Ioannis to close. Mariia, final word from you.
Sorry, just unmuting myself. I agree with everything that Noam and everyone has said, and Ioannis has said about the difficulties in making an impact with the work. And I think that's the key that our project was about. Is it's about delivering excellent research, but it's also about making an impact, so kind of converting this knowledge into policy change on the ground. And I think this is in itself a huge undertaking, a huge task. As Duncan, you mentioned, we did not envisage this to be so challenging to begin with. And I think this is something that needs to be definitely taken into consideration when designing projects of this sort, that the amount of work, time and effort that it takes to deliver the change on the ground, and the resources that are necessary. And we have been working at a challenging time schedule, challenging limited resources to try to deliver our best. And I think we've done very good job in being a champion for change in Ukraine, gathering all the stakeholders together, communicating with them, and keeping agenda for the IP court high. So I think it's focusing on allocating sufficient resources, time, and building a risk management effectively to take into account those challenging circumstances.
Yeah.
Thank you very much, John, for the question.
And I think, Mariia, your comments just really show that this was so much more than an academic project done by Queen Mary University of London. It was so much more in terms of its practical engagement and potential impact. So thank you for those comments. Olga, a final word from you.
Just a few words. Thank you very much for organizing this webinar, Duncan. It was very good to share the results of our project, and it was a great pleasure to be part of this team. And I truly hope that the results of our work will be useful to Ukraine, and that it will actually produce a beneficial outcome, and the court will be created, the report will be implemented, the recommendations will be implemented, and that this will be useful to Ukraine. Thank you.
Thank you, Olga. And I know that both you and Mariia, as I indicated earlier, you were both very committed to doing this for Ukraine, for the country from the beginning of the project. So your comments are very much appreciated. Of course, there'll be a recording of this event on the Queen Mary IP Institute website. So we'll continue to disseminate knowledge of this project through that link. Ioannis, final word from you as the non-IP lawyer in the project as you introduce yourself. I'll give you the final word.
Thanks so much, Duncan. Just very briefly to respond to John's excellent question. I think what we would try to do more next time that we are involved in such a project is trying to make a more frequent touch points with all the different stakeholders involved. And at the time we were doing the project, online communication was already in our lives, but it was not as day-to-day routine as it seems to be now. So I think going forward, trying to make all stakeholders feel that they own a part of a project and they contribute to this project and they are fully aware of what's happening, would be a certain way to the success of the project. And with online means, I think that's even more possible now. And I'll finish off by just again thanking you, Duncan, for the opportunity to be here, also when you started this, but also when you invited us now.
Yeah, and I think that's a great takeaway point, Ioannis, which is that getting stakeholders to take ownership of the project, I think is a great takeaway message from today's event. So thank you, Ioannis. Before I close this session, I quickly wanted to announce our next event. So I've shared my screen now to show you that our next online event will be on Wednesday, the 5th of May at 6 p.m. when the speaker will be Professor Annette Kur, who many of you will know was for many years at the Max Planck Institute for Innovation and Competition Law before she recently retired. So she's given us this wonderful title for her Herschel Smith lecture. Of course, many of you will know Herschel Smith was our benefactor for IP research and teaching at Queen Mary. And her title for the lecture is Fairness as a Legal Concept, a Guiding Principle for IP Law. So before we go, I will also thank not only the team, but our wonderful events manager, Christine Stokes, who put together the logistics for today's event. And Christine has kindly just posted in the chat box the registration details for that Herschel Smith lecture on the 5th of May. So I'll close this event, but I think it was really a wonderful insight to how much work was done in the project, how much was achieved, of course, with many things still left to be done in Ukraine with IP law and the IP courts, but a wonderful insight and a great set of presentations and discussions today. So thank you, everybody, and we'll meet again soon online, if not in person. Thank you. Goodbye.
Thank you. Bye-bye.
Thank you.
Bye-bye.